Welcome to Lecture 5B. We continue our discussion on legal positivism, and as we recall, this is a theoretical perspective that we are using to help us understand the answer to the question, what is law? In the last segment, we looked at one positivist, John Austin, and we learned about John Austin's definition of law. We learned that Austin is known as an analytical jurist, and his view or approach towards identifying what is law was to analyze the different types of laws, excluding those that he didn't want to consider as part of his theoretical framework, and just zooming in on one aspect, which is man-made law. And if you recall, Austin's definition of law was tied in with the concept of power and authority. Austin is known as a positivist because for him, the validity of a law is not dependent on its moral content. This, therefore, separates him from natural law thinking. If we recall, natural law thinking was to try to define law based on either the nature of man, the nature of man's surroundings, or on the basis of the existence of a creator or God. Positivists, therefore, take the view that the validity of a law is not dependent on its moral content, or in Austin's words, the merits or demerits of a law are not subject to its validity. Today, we are going to continue our discussion on legal positivism by looking at Hart's concept of law. The study of legal philosophy can be very confusing at times. John Austin's theory of legal positivism is very appealing in a very real sense. The idea that in society, law is viewed from the perspective of power, especially power in the hands of those that control authority, is very realistic. It's very scary maybe, but in many legal systems and in many societies, that is their view of the law. That law is used as a tool by those in power to subject citizens and people to control. One of the ways that we try and understand this is that the ideas that were propagated by Austin, as interesting as they are from a philosophical perspective, in terms of language, in terms of the words used, there are some weaknesses. If we recall, Austin chose to use words like sovereign, he used the words like command, he used words like sanctions or punishment to help him define what law is. But having used these words, his theory was criticized and heavily criticized because of the very words he used to define his theory. Hart used these words to criticize Austin's theory of law by saying, your theory of law, as interesting, as appealing as it is so full of weaknesses. And in fact, your concept in identifying what is law actually is a very primitive, narrow view of what law is. It is a view of law that exists in very primitive societies, where fear, the subjugation of citizens to control, these are societies that in Hart's views are societies that are not very modern in its thinking. Hart then says, as illuminating as Austin's theory is, it is so defective that we can't really use it. But we can use Austin's basic theory, and upon its theory, we can build a true understanding of what law is. So Hart destroys Austin's theory from a linguistic point of view, and upon the ruins of Austin's theory, Hart builds his own concept of law. Having done that, Hart's own theory of law was then criticized by someone called Dworkin. And this sort of reimagination of theories, criticism of the theories that were before, and upon the ruins of other theories, build your own theories and promote your own theories, continues in much of legal philosophy. But for now, let's explore Hart's concept of law. Hart, in his text, A Concept of Law, published in 1961, sought to provide a positivistic account of law. So, as much as he criticized Austin's theory of law, Hart and Austin are actually on the same front. They are both positivists. They both, therefore, view law as independent from its moral content, i.e., the validity of a law is not dependent on its moral content, but by some other measure. So even though they come from the same philosophical thinking, i.e., they were both positivists, their approach to identifying what law is was completely different. Hart, therefore, chose to improve upon Austin's theory, and in so doing, he destroyed Austin's central concept, i.e., the command theory of law. And what we want you to try and understand in terms of legal thinking and philosophical approach is the very process of thinking that takes place in this argumentative world. Hart's approach was to take Austin's theory, destroy it in its pieces, bit by bit, breaking it down and identifying its weaknesses, and then upon each weakness, collectively build his theory. And this style of thinking or approach is something that you should consider in how you approach things in argumentative approaches in terms of academic thinking, i.e., not to be personally critical, but to be critical of a theory, taking it apart bit by bit, and then building your own theory or concept. So, a concept of law is a positivistic theory because it rejected the notion that law's moral force was grounded in morality. So he is, therefore, just like Austin, rejecting the notion that the validity of a law is dependent on its moral content. Hart's theory provided an analytic account of the criteria of legality, the criteria a norm must satisfy in order to count as a legal norm. So these were concepts that tried to identify the nature of law. Now look at the words that Hart uses to criticize Austin. He said that when Austin was clearly wrong, at least he was wrong clearly. It's a way of saying that you are credited for being clear with your theory, but your clarity in theory is a clarity that is erroneous, that is wrong. It's a theory that is wrong. As clear as it may be, as illuminating as it may be, there are fundamental defects in Austin's theory. Austin was determined, says Hart, to use in his analysis only clear, hard empirical terms, intelligible to common sense. But for this laudable enterprise, he chose the wrong fundamental notions. Even though you were clear, your theory was so wrong, but at least you were wrong clearly. So what then were Austin's fundamental notions that Hart found particularly disturbing, or erroneous. Austin's analysis of the elements of the concept of law, such as command, duty, sanction, habit, and sovereign, were picked apart by Hart. Every word was criticized. Every word was found to be wanting. Every word had weaknesses that Hart explored, exploited, and therefore dismissed. Hart argues that rules are not necessarily measured in terms of commands. There are rules or laws that confer power, for example. Surely such laws are not commands. They merely facilitate power. So Hart refers to these as power-conferring rules. Rules that confer powers on individuals, institutions, or government. So by doing this, Hart argues that law is far too complex to be confined through the narrow definition given by Austin. What is the narrow definition? That law is the command of a sovereign, and people obey the law because they are afraid of the punishments or sanctions that can follow. Hart says that definition doesn't explain the complexity of law. Law exists in society, and there are laws that grant power to people. There are laws that grant power to institutions. Austin's theory cannot explain this, or did not explain this. So, Hart therefore argues that the use of words are very important. Inquiries into the meaning of words merely throw light on words is false. So any inquiry that attempts to use just words without attempting to give light to its meaning is going to be problematic. If you choose to define a concept, then you will always be stuck by the definition that you choose to give it. So words used to define law were one of the weaknesses of Austin's theory. Because once you choose to use a word like command or sovereign, you will be stuck by the words that you choose, and people can find weaknesses in that description. Not all countries have a sovereign. Who is this sovereign? Law is not all about commands. So, for Hart, defining the law is not the best approach, because words that are used to define a concept will limit the concept to that definition. Choosing to use words to define the law will mean that you will be restricted by the very definition you give. Instead, Hart proposes to use the word description. He says it is better to describe the law because law is a sociological fact. It is better to describe the law than to define it. And if you remember in your very first lesson, we talked about this. We asked the question, what then is law? And the example given to you was the idea of the elephant and the men who were visually impaired, touching and feeling small parts of the bigger being and identifying the animal based on what they feel and sense in the very narrow confines of that space. So for Hart, it is better to describe the law. So what did Hart do? What Hart did was to build upon the criticisms leveled at Austin's theory to propose his description of the law as being his concept of law. And to do this, Hart decided to describe the law using the concept of rules that impose duties on each member of that group that determines standards of behavior. He says that in a developed and complex society, these primary duty-imposing rules would need an additional layer of rules to address the deficiencies of the primary duty-imposing rules. Rules that impose duties on citizens are rules that Hart argues was Austin's definition of law. It is a system in which society merely has rules that impose duties on people, obligations to do things, and a punishment to follow if you don't do this. For Hart, that is a reflection of a very primitive society. In a developed and complex society, you need an additional layer of laws or rules, and he called them secondary rules. The secondary rules that he talks about are rules of recognition, change, and adjudication. So what does Hart mean by these things? What he means by these things is, firstly, the criticism against Austin's theory is that, as good as it is, it only reflects a very small fragment of how society exists. Laws that impose duties are merely the first layer in a society that is not developed. It is common in primitive societies to have a system of rules that merely punishes individuals for things that they do or don't do. But in more complex societies, an additional layer of rules are needed. That society needs to have a system of laws in which we recognize authority, or we recognize who is in power. A developed and complex society will also need a set of laws to determine how to change laws within that system. How do we amend laws that we are no longer happy with? How do we amend laws that need to change with the evolution of time? Therefore, we need specific guidance as to the process in which we can change laws. Lastly, he says, citizens in this modern and developed society are likely to have disputes. So we need a system of laws and rules that govern the relationship between people in the society and govern the relationship in the event that society has a dispute. Immediately we can see that there is merit in Hart's theory, because what Hart is saying is, therefore, law is far more complex than the very primitive and narrow approach taken by Austin to see laws as primarily about duties and punishments and sanctions and power. Laws are therefore far more complex, and society is far more complex than the basic idea that Austin is talking about. So Hart's concept of law attempts to destroy Austin's theory on the basis of language or linguistics. It criticizes Austin's theory because Austin chose to define law. And Austin chose to define law by using very specific words like command, sovereign, obedience, punishment, or sanction. Hart says that this approach in defining the law is defective. Even though it's illuminating to see and understand Austin's theory, it is defective because it chooses to define the law, and in defining the law with the words that Austin uses, the law becomes very narrow in its scope. Hart is of the view it is better to describe the law than to define it. And in his description of law, his concept of law, there are two layers to law. In a system, in a society, there are primary duty-imposing rules and secondary rules that impose a slightly different layer. The secondary rules of recognition and adjudication, for example, all provide a very complex layer to his understanding of the law. In other words, laws are not just about imposing duty, but they also are necessary in order to help us understand how to change laws, how to adjudicate in the event of dispute, and a system of laws that help us recognize what is legitimate authority within a society. However, as I mentioned at the very beginning, even though Hart's description of law is illuminating, it too faced criticisms. Among others, there are those that criticized Hart for his failure to provide an express definition of what legal rules are. Another criticism is the fact that Hart's treatment of the legal system failed to take into account the role of principles in the operation of the law. What are principles? For example, in a dispute, as much as Hart promoted the idea of rules of adjudication, for example, how would judges decide a case? Even though there are rules in which judges may have to follow in order to decide cases based on principles of precedent, for example, but there are other principles operating within the legal system. Judges, for example, may have particular mindsets, particular socio-cultural backgrounds or socio-religious backgrounds or socio-political backgrounds that sometimes might shape their views and how they decide cases. So the criticism here is that although Hart's concept of law looked at rules as a basis to identify a legal system, a modern complex social system, it failed to take into account underlying principles in the operation of law. Such a view was taken by Ronald Dworkin. That's him. And for Dworkin, every legal system or interpretation has an underlying theory about the general character of law. And so rules themselves cannot explain everything in relation to a legal system. There are principles which serve as guidelines. So even though judges interpret laws, they do so by looking at principles, moral principles, the reasons for the decision. What are the underlying background issues that makes a judge decide in a particular way? His background as a judge certainly does influence the way he thinks, where he went to school, what socioeconomic strata he belonged to. So principles, therefore, enrich the decision-making process. And in the context of understanding what law is, according to Dworkin, there's an added dimension which Hart failed to explore. What then is the future of legal positivism? In this view, we see that discourse of positive law is now falling into disuse. It is being disregarded. In other words, the modern context or view of what law is that it's moving away from positivism itself. In fact, Murphy suggests that even leading contemporary positivists like Hart himself no longer refer to positive law. Part of the argument is that positive law, or the definition or description of positive law, was meant to separate laws enforced by courts from other kinds of law, especially divine, customary, and natural law. The argument by Murphy is that it's actually no longer necessary to describe laws as positive laws. The laws that we see today are primarily man-made laws in most societies. So distinguishing them from God-made laws is actually rather redundant. So positivism as a theoretical concept was very dominant or prominent for many centuries. But over the last few years, the concept of positive law in itself is actually facing a decline. People no longer argue about positivism and natural law. So what can we draw in conclusion with this particular lesson? The definition of law is continuously evolving. And this is something that we've mentioned at the very beginning. At the very beginning, if you recall, when we asked the question, what is law? We said that it is a quest for the impossible. It is a quest for that which is impossible to define. And the reason perhaps why it is impossible to define is that it is an evolving concept. It is a concept that is not static. There is no one singular concept or view of law that is going to be relevant throughout time. Some may argue, for example, that classical natural law theories that have become part of what we call the universal declarations may perhaps be those that are timeless and unchanging. But even then, there are such different views about what are universal human rights, for example. So, the definition of law is continuously evolving. We have looked at natural law perspectives, we have looked at positivist perspective. And even amongst the main positivists that we've explored, we find that there is a difference of approach. One chose to define, i.e. Austin, one chose to describe. And it even leads us to ask whether there is a difference between defining or describing. We've also learned that there was a fierce debate between natural law and positive law. We say fierce, and we say was, because the debates actually fizzled out. Much of these arguments were very relevant at the turn of the 19th century, leading up into the 20th century, but today there's less discourse on these issues. We've provided a link for you. You can have a look at a more descriptive element of these arguments. It's also important to know that we did not cover the length and breadth of the various philosophers, both in the positivist school of thought as well as under natural law. We've just covered a few to give you an idea of the kind of debates and arguments that happen in this philosophical realm. And what have we done? We've given you theoretical perspectives about viewing what law is, and in the context of natural law, what law ought to be. We conclude this session, and we hope that you will do the reading and comply with some of the expectations in terms of your tutorial questions. We'll see you again for the next lecture.